Claude responded. My lawyer called me on a Sunday afternoon at 4:12, which by itself should tell you something, because in 19 years of being his client, Warren Coates had. My lawyer called me on a Sunday afternoon at 4:12, which by itself should tell you something, because in 19 years of being his client, Warren Coates had never once called me on a weekend. I was in the garage in Tulsa, Oklahoma, regluing a chair leg that didn't need regluing, which is the kind of thing a man does when his wife has been gone 8 months and the house is too quiet for him to sit still in it. I picked up on the first ring. He said, Ray, it's Warren. I need you to come by the office tomorrow morning. First thing. I said, Warren, it's Sunday. What's going on? He said. I'd rather show you than tell you over the phone. Can you be here at 9? There was a particular flatness in his voice that I recognized immediately because I'd spent 31 years as a claims adjuster for a mid-size insurance carrier, and I know exactly what a man sounds like when he has found something he doesn't want to say out loud until he's looking you in the eye. I said, I'll be there at 9. I hung up. I finished the chair leg even though it didn't need finishing. I fed the cat, a gray tabby named Wendell, that my daughter Carol had picked out at the shelter the year after my wife Marilyn passed, on the theory that a man alone in a big house needed something that depended on him. I set my alarm, even though I hadn't needed an alarm since I retired, and I lay in bed that night doing the thing I've done my whole life, which is running probabilities in my head instead of sleeping. Warren Coates had been my attorney since 2007, back when it was just an estate plan and a living will, nothing complicated, 2 kids and a paid-off house, and a modest but respectable 401k that Marilyn and I had built dollar by dollar over 3 decades of both of us working. His office was on the second floor of a converted bank building on Boston Avenue, the kind of place with a brass plate on the door and a receptionist named Doris, who'd been there longer than some of the lawyers. I got there at 8:52. Doris didn't smile at me the way she usually did. She just said, He's waiting for you, Ray, and that told me everything I needed to know about how bad it was going to be before I even opened his door. Warren was 63, silver-haired, precise in the way that good estate attorneys are precise, and he did not do small talk that morning. He shut the door behind me. He didn't sit behind his desk the way he usually did. He sat in the chair next to mine, which I noted, because in 19 years he had never once done that. He set a folder on the low table between us, and he said, Ray, 3 days ago, my office received a request from the Tulsa County Probate Court for a certified copy of your estate file because a petition has been filed to modify the distribution of your trust. I want you to look at this before I say anything else. I opened the folder. The first page was a document titled Amendment to the Raymond Earl Whitfield Revocable Living Trust, dated the 14th of January, 4 months earlier. It restructured the entire trust. It removed my daughter Carol as co-trustee. It removed my son David as a named beneficiary entirely. It named, as sole successor trustee and primary beneficiary of 90% of the estate, a man named Curtis Bell. At the bottom of the page was my signature, notarized, with a notary stamp from a woman named Renata Cho, license number printed clean beneath a raised seal. I looked at it for a long moment. I said, Warren, I have never seen this document in my life. He said, I know, Ray, because I drew up your last trust amendment myself in 2019, and I have never seen this one either, and neither has anyone in this office. And the notary seal on that page belongs to a woman who, according to the Oklahoma Secretary of State's public registry, does not exist. I want to tell you who Curtis Bell was, because that's the part that took the wind out of me, the way the document itself hadn't quite managed to. Curtis was my daughter, Carol's husband. 46 years old, ran a small property management company out of a strip mall off 71st Street, the kind of business that always seemed to be one contract away from either taking off or falling apart, and had been telling anyone who'd listened for 2 years that he was about to close on a shopping plaza in Broken Arrow that was going to change everything for them. He called me every couple of Sundays to ask how the knee was holding up since the surgery, and to ask, with what I had taken at the time for ordinary concern, whether I'd given any more thought to consolidating my accounts now that Marilyn wasn't around to help me keep track of things. I had liked Curtis. in the careful, provisional way you like the man who married your daughter before you've decided whether he's earned it. Marilyn had liked him less. She told me once, the year after Carol married him, sitting at our kitchen table with a legal pad where she used to write out our monthly budget in her small, square handwriting, "That man smiles like it's a transaction, Ray. Watch him." I had told her she was being hard on him. She had said, "I hope I am." Warren said, "The petition asks the court to confirm the amendment as valid and to authorize an immediate transfer of trust assets to Mr. Bell as successor trustee on the basis that your prior mental capacity has been called into question and that this amendment reflects your most recent and most reliable expression of intent." I said, "My mental capacity," he said. "There's a supporting affidavit from a Dr. Patricia Nolan, a neuropsychologist in Tulsa, describing 2 capacity evaluations she conducted with you in November and again in January, and concluding that you exhibited, at the November evaluation, mild but measurable impairment, and at the January evaluation, further decline consistent with early-stage dementia, sufficient to raise concerns about your ability to manage complex financial decisions independently." I said, "Warren, I have never met a Dr. Patricia Nolan. I have never had a capacity evaluation of any kind, not once, not ever." He said, "I believe you, Ray, and I already checked. There is no Patricia Nolan licensed as a neuropsychologist anywhere in the state of Oklahoma. I called the state licensing board myself yesterday afternoon before you got here because I wanted to know before I said a word to you." He reached for his own phone, and he dialed a number, and he said into it, "This is Warren Coates. I need you to pull every file we have on Raymond Whitfield, the complete history going back to 2007, and I need a certified letter drafted to the Tulsa County Probate Court today stating that this office has no record of preparing, witnessing, or notarizing the document filed under case number, and read me that case number now." He wrote it down. He hung up. He looked at me and he said, "What do you need from me, Ray?" I said, "Everything you just started, and one more thing." He said, "Name it." I said, "Don't let this get quiet. I want noise." He said, "Ray, I've been an estate attorney for 31 years, and I have never once let a forged document sit quiet in a courthouse. I'm not starting with yours." I picked up the folder. I drove home along Riverside Drive with the windows down even though it was February and cold enough that it didn't make sense because I needed the air moving across my face while I thought. Curtis had built a document with my name and a stranger's forged medical opinion and a fake notary seal, and he had filed it with a court, and he had done all of it while calling me on Sundays to ask about my knee. I did not feel rage, not in that first hour, and I want to be honest about that, because I think people expect rage, and I didn't have it. What I had instead was the particular cold clarity that 31 years of adjusting insurance claims puts into a man. You spend 3 decades reading fraudulent claims for a living, learning to see the seam where a fabricated story doesn't quite match the physical evidence, and eventually that skill stops being a job and becomes the way you see everything. I had read thousands of forged documents in my career. I had just never expected to read one with my own name at the bottom of it. My name is Raymond Whitfield. I am 68 years old. I have lived in Tulsa, Oklahoma, my whole life, and the man who forged that trust amendment had made exactly one miscalculation, which is that he assumed a widower with a bad knee was a man whose life had gotten smaller and softer to match his grief. What he'd actually been circling for 2 years was 31 years of professional pattern recognition and a filing cabinet that would make a state auditor weep with gratitude. He had 90 days before the court hearing, and he had no idea what those 90 days were about to cost him. I spent my career at Cimarron Mutual Insurance, starting as a junior adjuster in 1979 and retiring in 2019 as a senior claims investigator, which meant that for 4 decades, my entire professional function was determining whether a claim was true. You learn things doing that work that don't leave you. You learn that liars tell stories that are too clean, too complete, with no ordinary human mess in them. You learn that real events leave inconsistent, contradictory, badly remembered traces, and fabricated ones leave suspiciously tidy ones. You learned to trust a parking receipt over a person's certainty about where they were standing. Marilyn used to say I couldn't watch a television courtroom drama without narrating the holes in the plaintiff's story. And she wasn't wrong, and it never once bothered her, because she did the same thing with numbers. She'd been a bookkeeper for 34 years at a lumber supply company on the east side of town, and she balanced her own checkbook to the penny every month of her life out of what she called professional pride, and I called something closer to a moral position. We bought our house on Terwilliger Boulevard in 1988, a modest brick two-story in a neighborhood of oak trees old enough that their roots had started lifting the sidewalk slabs. We raised David and Carol there. Marilyn kept a small spiral notebook in the kitchen junk drawer, the same one for years, where she'd jot down things worth remembering. A grocery list, next to a Bible verse, next to something one of the grandkids said that made her laugh. I found that notebook in her nightstand after she died in April of last year, 11 months after the pancreatic cancer diagnosis that gave us just enough warning to say what needed saying and not nearly enough time to say it slowly. I have read every page of that notebook more times than I'd admit to a stranger. Our son David was 41, an electrical engineer in Denver, called every Tuesday whether there was news or not, and had flown down twice in the 6 months after his mother died without being asked. Our daughter Carol was 39, lived 20 minutes away in Jenks with Curtis and their 2 boys, and had her mother's quick mind pointed, in the last several years, in a direction her mother would have quietly worried about. Carol was not a bad person, and I want to be careful saying that, because this story doesn't work if you hear it as a story about a bad daughter. She was a person who had spent a decade being slowly recalibrated by a husband whose charm had, over time, stopped costing him any effort at all, the way a con stops feeling like a con to the man running it once he's run it enough times. I'd known within the first year of Curtis marrying into the family that he was a man who did math on people without meaning to, the way some men can't help sizing up a room. Marilyn had known faster than I had. Driving home from the first Thanksgiving with Curtis at our table, back in 2013, she'd said, "Ray, that man is always calculating something," and I'd said I saw it too, and she'd said, "I know you do." I just want it said out loud once, so we remember we both saw it. The early years were unremarkable enough on the surface. Curtis and Carol bought a house in Jenks in 2015. The boys came along in 2016 and 2018. Curtis was warm at every holiday, attentive to details, the kind of son-in-law a man is supposed to feel lucky to have. What I noticed and didn't act on started around 2021, questions about whether Marilyn and I had updated our estate plan since the grandkids were born, comments about the market value of the Terwilliger house, an offer, phrased as a favor, to look over my investment accounts, since he worked around money for a living. It was the pattern of a man who had decided that being near something valuable was a form of already owning part of it. After Marilyn died, that pattern changed the way a plan changes once an obstacle is removed. The estate conversations got more specific. In the fall of last year, 7 months after the funeral, Curtis asked me directly, at my own kitchen table, whether I'd thought about giving him power of attorney, just in case, given that I was living alone now, and, in his words, none of us are getting younger. I was walking 3 miles most mornings along the river, and my doctor had told me at my last physical that my blood work looked better than men 15 years younger than me, and I understood in that moment that Curtis's question had nothing to do with concern for my well-being. What I did not yet understand was how far he had already gone. I found out when Warren called me on a Sunday afternoon. I drove straight from Warren's office to a woman named Deborah Ashe, an elder law attorney whose practice occupied a converted house on South Utica Avenue, 3 blocks from a coffee shop I used to take Marilyn to on Saturday mornings. Warren had referred me to her 2 years earlier, almost as an aside, when I'd asked whether he knew anyone who handled guardianship and trust litigation in case it ever came up. He'd said, "I know exactly one person in this city who wins those cases more than she loses them, and her name is Deborah Ashe, and she doesn't take appointments, you just show up." I had filed that piece of information the way I file everything, in a place I could pull it back out precisely when I needed it, which turned out to be 19 hours later. Deborah was 54, compact, sharp-eyed, with a whiteboard behind her desk that tracked 3 active case timelines in 3 different colors of marker. She was on a call when her assistant showed me in. She held up one finger, finished the call in under a minute, and said, "Sit down. Tell me what happened." I sat down. I put the folder on her desk. I said, "My son-in-law filed a petition to seize my trust, using a forged amendment with my signature on it, a fake notary seal, and a fabricated medical evaluation from a neuropsychologist who doesn't exist." Deborah looked at the folder without opening it, yet. She said, "How do you know all of that?" I said, "Because my attorney of 19 years never drafted that amendment, because the notary license number on that seal comes back to nobody at the Secretary of State's office, and because I have never sat across from a neuropsychologist in my life, and I can prove where I actually was on both dates listed in that fake evaluation." She said, "Where were you?" I said, "November 11th. I was in Denver visiting my son. I have the flight confirmation and my son's testimony, and a hotel folio with a timestamp. January 9th, I was at the Tulsa County Assessor's Office disputing my property valuation. I have the appointment confirmation, the stamped paperwork, and a parking garage receipt time-stamped 9:20 in the morning." Deborah looked at me for a second. She said, "What did you do for a living?" I said, "Insurance claims, investigator, 31 years. She said, "That explains the receipts." She pulled the folder toward her and read it in total silence for close to 2 minutes, turning each page slowly, the way people read who actually intend to remember what's on it. When she finished, she closed it and said, "Mr. Whitfield, if this document is what it appears to be, your son-in-law has committed forgery, fraud on the court, identity theft, and impersonation of a notary public, and depending on how the medical evaluation was constructed, potentially fraud involving a licensed profession as well. Those are separate felonies under Oklahoma law." I said, "I assumed as much." She said, "How do you want to proceed?" I said, "I want the petition thrown out. I want the forged documents entered into a permanent record that follows Curtis Bell everywhere he tries to do business again. And I want to be sitting in that courtroom when he understands exactly what he walked into." Deborah was quiet a moment, and then she said, "Those are 3 reasonable goals." She picked up a legal pad. She said, "Now tell me everything, from the beginning, and don't leave out what feels irrelevant. Let me be the judge of that." I talked for the better part of an hour. She wrote the entire time and interrupted only 3 times to ask whether Curtis had ever had legitimate access to any of my accounts, which he hadn't, whether Carol knew what he'd filed, which I didn't know yet, and whether I had any written record of the conversations where Curtis had raised power of attorney and estate consolidation. I told her I had contemporaneous notes on every meaningful conversation I'd had in the last 3 years, a habit I picked up decades ago and never once considered breaking. She set down her pen and said, "In 26 years of this practice, I've had maybe 3 clients walk in here as prepared as you are." I said, 31 years of reading other people's fraud teaches you to document your own life like somebody might come after it someday." She almost smiled. She said, "Let's talk about what we're going to do." The first call Deborah made, with me still sitting there, was to the Tulsa County Probate Court Clerk's office, entering her appearance as counsel of record, which immediately changed the temperature of the whole proceeding because it told the court and everyone else involved that this was not going to be a quiet rubber stamp. The second call was to a private investigator named Roy Kessler, a heavyset, unhurried man who worked out of a small office near the fairgrounds, and who Deborah said cared more about what was true than what anybody wanted to be true. Kessler called her back 4 days later with what he'd found, and what he'd found was not a moment of temptation Curtis had given into on a bad afternoon. It was an operation. Kessler had traced an 18-month pattern of Curtis researching Oklahoma trust and guardianship law, locating a document mill outside Broken Arrow that produced convincing template legal forms for a fee and no questions, and constructing an entire fictitious paper trail, 2 fake capacity evaluations, a phantom notary license, and a signature copied, near as Kessler could determine, from a letter I had actually signed and mailed to Curtis 2 years earlier, co-signing a small business loan guarantee for his property company, back when I still trusted him enough to put my name on something of his. He had used my own signature from a piece of paper I had signed to help him to forge the document meant to take everything from me. Kessler had also found that Curtis had opened a business account 11 months earlier under an entity called Bell Family Holdings, LLC, registered in Wagoner County. Stated purpose listed as family asset and property management. No clients, no revenue, no deposits. An empty structure, built and waiting for money that had not yet arrived. Deborah looked at that filing for a long moment and said, "He built the receiving account before he built the fraud. He was that confident you'd never fight back." I said, "He's known me 13 years. She said, "He saw a widower with a bad knee, living alone in a big empty house. He saw exactly what he wanted to see." I said, "My wife told me years ago that man was always doing math." Deborah said, "She was right. He was just running the numbers on the wrong variable." Now I have to tell you about the conversation with Carol, because it's the part of this whole ordeal that cost me more than anything Curtis did, and it's the part I've turned over the most times since. I called her on a Tuesday evening, 11 days before the hearing, because Deborah had told me it needed to happen before I walked into that courtroom, so I'd know where my daughter stood. Carol answered on the second ring, sounding like herself, sounding like nothing was wrong, which somehow made it worse. I told her to let me finish before she said anything, and then I told her everything. The folder, the forged signature, the fake doctor, the empty LLC in Wagoner County. When I stopped talking, the line went quiet long enough that I checked to see if the call had dropped. She said, "Dad, I didn't know about any of this." "I swear to you, I didn't know," I said. "What did you know, Carol?" A pause. She said, "He told me he'd filed something to protect you. That living alone at your age, after Mom, it wasn't safe for you to be managing everything by yourself anymore, and that you'd probably fight it at first because you're stubborn, but that it was the responsible thing to do." He showed me a summary, not the whole filing. He said the legal parts were too technical to bother me with. I sat with that phrase for a second. The legal parts were too technical, the exact language a man uses when he needs his wife agreeable without being informed. I said, "Carol, are you going to stand behind what he did, or are you going to tell the truth?" A longer silence this time. Then, quietly, the sound of somebody finally looking straight at something she'd been avoiding for a while. She said, "I'm going to tell the truth, whatever it costs." I said, "Meet with Deborah tomorrow morning. Bring anything in writing, texts, emails, all of it." She said, "I have texts, Dad, a lot of them." I said, "I know you do. And Carol, I love you, and that's not conditional on any of this. But what Curtis did is a crime, and how you handle the next 11 days matters. For you and for the boys." She said, "I know." And right before we hung up, she said, "I'm sorry I didn't ask more questions." I said, "Start asking them now." Deborah met with Carol the next morning and called me that afternoon. 53 text messages spanning nearly a year, showing that Carol had understood there was some kind of legal filing underway, but had genuinely believed it was a legitimate protective measure, not a forged instrument built to strip her own brother out of the family and hand everything to her husband. She'd been managed, deliberately, by someone she trusted, and Deborah said that distinction between complicity and deception was going to matter both legally and, for what it was worth, personally. David flew down from Denver 2 days before the hearing without being asked, the way he always did, and we sat up late at my kitchen table while I told him everything, and he listened the way his mother used to, all the way through, without interrupting, once. When I finished, he looked at the table a moment and said, "Dad, are you okay?" I said, "I'm functional." He said, "That's not the same thing, Dad." I said, "No, it isn't. I'll be okay after Friday." He said, "Mom used to say you were better at taking care of everybody else than yourself." I said, "She wasn't wrong about much." The Tulsa County Probate Court on the morning of the hearing looked like every courthouse looks. Beige walls and fluorescent light, and decades of ordinary human urgency worn into the carpet. Deborah met me in the hallway at 8:40. David stood beside me. Warren Coates came in person, at Deborah's request, without hesitating for a second when she asked. At 8:55, Curtis arrived with his attorney, a composed, silver-templed man named Franklin Boyd, who had the bearing of somebody who expected an easy morning. Curtis wore a good suit and looked exactly as composed as he always did, right up until he saw me standing in that hallway, and his face recalibrated for a fraction of a second before he caught it. He said, "Ray, I didn't expect you'd come yourself." I said, "It's a hearing about whether I'm competent to run my own life, Curtis. Where else would I be?" He said, "I hope you know this came from a place of real concern." I said, "I know exactly where it came from." His attorney touched his elbow and steered him into the courtroom. The judge was the Honorable Renata Fields, 17 years on the probate bench, with a well-earned reputation for having no patience for wasted time. She reviewed the file, looked up, and said, "This is a petition to modify a revocable trust in the matter of Raymond Whitfield. Counsel, identify yourselves." Franklin Boyd identified himself for the petitioner, Curtis Bell. Deborah identified herself for Raymond Whitfield, the trust grantor. Judge Fields looked at Deborah and said, "I want to confirm on the record that Mr. Whitfield is present and consents to appearing today." I said, "I am present, Your Honor, and I insisted on this date." The judge looked at me with an expression that was careful and neutral and had something underneath it that might have been interest. She said, "Very well. Mr. Boyd, present the basis for the petition." Franklin Boyd stood and laid it out in the practiced language of a man who'd made this kind of argument before, describing the trust amendment, the two capacity evaluations, the physician's affidavit, framing his client as a concerned family member seeking a legal mechanism to protect an aging widower's assets. He said the evaluations had been conducted by a licensed neuropsychologist, a Dr. Patricia Nolan. Judge Fields looked toward the gallery, where Warren was seated, and said, "Mr. Coates, is there a reason you're present today?" Warren stood and said, "There is, Your Honor. My office drafted Mr. Whitfield's actual trust and every prior amendment to it, and we have no record whatsoever of preparing, witnessing, or being consulted on this amendment. I've submitted a certified letter to that effect, along with confirmation from the Oklahoma Secretary of State that the notary license number listed on this document does not correspond to any registered notary in this state." The courtroom did the thing courtrooms do at a moment like that, where every person in the room goes suddenly and completely still. Judge Fields turned to Franklin Boyd and said, "Counsel, I want to be precise with you. I have a sworn statement that the notarization on your client's central exhibit is fraudulent. Do you have a response?" Boyd's voice had lost the confident register it started with. He said, "Your Honor, I was not made aware of any issue with the notarization prior to this morning." The judge looked past him, directly at Curtis, and said, "Mr. Bell, please stand." Curtis stood. She said, "Are you aware that submitting a fraudulently notarized document to this court, along with a fabricated medical evaluation, constitutes multiple felony offenses under Oklahoma law?" Curtis was quiet a second too long, and then he said, "Your Honor, I can explain the circumstances." Judge Fields said, "I expect you'll have the opportunity to, though probably not to me." She looked back at Boyd. "I am suspending this proceeding. I am not dismissing it. I am referring the entirety of this filing to the Tulsa County District Attorney's Office for criminal review, and I am entering a formal notation in this record that the medical and notarial basis for this petition has been affirmatively challenged and disproven. Mr. Whitfield, I want to state clearly, for the record, that there is no finding of incapacity against you in this proceeding, and this court takes very seriously what you have been subjected to." She looked once more at Curtis and said, "Mr. Bell, I'd strongly advise you to speak with counsel about your next steps immediately. This court is adjourned." She stood and left, and the room reassembled itself around what had just happened. Deborah touched my arm and said quietly, "That went exactly the way it needed to." David stood beside me and put his hand on my shoulder without saying anything, which was exactly the right amount to say. Across the room, Franklin Boyd leaned toward Curtis, talking low and fast. Curtis sat very still. The suit and the haircut, and 13 years of careful charm, all still technically in place, and meaning absolutely nothing now. He glanced up once, not deliberately at me, just the involuntary look of a man trying to relocate himself inside a world that had just rearranged around him. Our eyes met for a second. I didn't look away, and I didn't say anything. I just watched him with the plain, settled expression of a man who had run this exact outcome in his head 11 days earlier and found the numbers landing precisely where he expected them to. The district attorney's office opened a formal investigation within 2 weeks. Curtis was charged in the spring with forgery, fraud on the court, impersonation of a notary public, and financial exploitation of a vulnerable adult, which is the Oklahoma statutory language for exactly what he had planned to do with the rest of my life. His property management company lost its largest contract within a month of the charges becoming public, and the rest of his clients followed within the year. Carol filed for divorce that summer. She brought 53 text messages to Deborah's office and told the truth to every question anyone asked her, and the distinction between being deceived by someone you trusted and choosing not to look closely enough is one I decided, in the end, to make in her favor, because she's my daughter, and because her mother would have wanted me to. Carol and the boys live in a rental near Jenks now, 25 minutes from my house on Terwilliger. She comes for dinner on Thursday evenings. She asks more questions than she used to, about everything, not just about money. David flew down for the first of those dinners, and the three of us sat at my kitchen table without the weight that had been sitting on top of every conversation for 2 years. And at some point Carol said, "Dad, Mom knew about him, didn't she?" I said, "Your mother knew things before most people finished thinking them." Carol said, "What did she know?" I said, "She knew he was always doing math. She just knew what kind of math it was, and she said it out loud once, so we'd both remember we saw it." Carol looked down at her plate for a while, and then she said, "I should have asked her more when I had the chance." I said, "Ask them now." I'm still here. Marilyn's notebook is still in the nightstand where she kept it. I haven't moved it, and I don't intend to. The trust is rebuilt now, held properly, David and Carol as equal beneficiaries, Deborah Ashe as successor trustee, everything exactly where I know it is, and documented in a way any auditor could verify, inside of 15 minutes. I am 68 years old. I still walk the river most mornings. I still keep contemporaneous notes on every conversation that matters, a habit that started as a professional reflex 30 years ago and turned, somewhere along the way, into something closer to how I love the people I love. My father, who drove a delivery route in this same city for 38 years, used to tell me that a man's whole life comes down to what he builds and what he's willing to protect. I built something with Marilyn over 4 decades of ordinary effort. Somebody tried to take it out from under me while I was still learning how to live in the house without her. I protected it with 3 decades of professional habit, one very good attorney, and a friend who picked up the phone himself on a Sunday because he refused to let it wait. That's the part of this that actually matters. That's what she left me equipped to survive. Claude responded, "The thing I keep coming back to isn't the courtroom. It's the notebook in the nightstand proof that love, written down in small ordinary moments, outlasts. The thing I keep coming back to isn't the courtroom. It's the notebook in the nightstand proof that love, written down in small ordinary moments, outlasts the person who wrote it and protects the people left behind. Keep your records, yes, but really keep your people close. Ask them questions while you still can, and trust the quiet ones who saw the truth before you did. That's the real inheritance." A small note for you. This story was written and fictionalized by AI for entertainment purposes, while also hoping to share a genuine, positive life lesson.